come before the court this morning is Yvonne Jones versus Brentwood Health Center et al. Musical chairs. I don't think this has ever happened before. Next time. Next time, maybe it would be easier just to move the appellants.
I didn't want to presume to switch it.
Then we would get all
I was-
cases, right?
Wherever you want me.
Good morning. Each side will have 15 minutes to present oral argument this morning. The appellant may reserve up to 5 minutes for rebuttal. If you plan to reserve any time, if you let me know when you get started, I'm keeping the clock and you can see that it's on the wall over there as well for your use. The arguments are being recorded. Please stay behind the podium, keep your voice up, and not use the names of any victims or minors, as this is going to be posted on our YouTube site. Obviously, the name of the party, you can use the name, it doesn't apply. The judges have read your briefs. We're ready to see when you are. Ready?
I'd like to reserve 5 minutes, please.
Certainly.
May it please the court. My name is Doug Leake, and I'm here on behalf of the defendants, appellants, collectively referred to as Brentwood. And on behalf of Brentwood, we ask that this court first reverse the trial court's denial of our motion for stay and to compel arbitration, or alternatively, reverse the trial court's denial of our motion for relief from judgment, and then remand this matter for a hearing to consider the deposition testimony of the plaintiff's sister, Jacqueline Carter. With regard to the motion for stay and to compel arbitration, it is undisputed here that the plaintiff, Yvonne Jones, was not capable of reading and signing the agreement at issue that includes the arbitration clause. We know that because at page 3 of their own brief, the plaintiffs, they admitted that Yvonne Jones required 24/7 hours care. It is also confirmed by her sister, Jacqueline Carter, at her depositions from pages 26 to 28, that her sister was not capable of reading and signing this agreement. It is also undisputed that on September 24th, 2018, Jacqueline Carter, plaintiff's sister, was the representative when her sister was admitted and when Jacqueline Carter signed the agreement at issue. The question:
how are you defining representative? Did you have any legal capacity of a guardian, a power of attorney, or anything of that nature?
This case falls under, just like the case of the second district in Brown, in Brown versus Extended Care, under apparent authority. It is admitted she was not the power of attorney. She admitted that. But in her deposition, she explicitly testified that she was the representative. And the factors that go into it, it is undisputed.
So some kind of agency theory is what you're alleging here, nothing more, just general principal agent law.
Yes, under apparent authority.
Did the trial court analyze the authority under the concept of apparent authority?
It did not explicitly go to that point. It just said, based upon there's no legal thing present here. The premise of our appeal here is the apparent authority, and we ask that this court follow the second district case of Brown versus Extended Care that addressed the apparent authority. And here, procedurally, which the trial court limited its review of the procedural aspect of whether or not the agreement was conscionable, we believe that it was procedurally conscionable because it is undisputed that Yvonne Jones could not handle her finances, insurance, and especially any decisions with regard to the nursing home. It is also undisputed that Jacqueline Carter was her caregiver for several years and handled all those matters for her. She also admitted that she was the representative, and she signed the documents as her representative.
Was Ms. Jones asked or able to make any representation on whether Ms. Carter could enter these type of contracts for her orally?
In terms of the situation on September 24th, and we've heard the testimony of Olivia Tripp from Brentwood, is that all the dealings dealt specifically with Jacqueline Carter for the fact that Yvonne Jones was not in a condition to engage, to sign, and read the agreement. That's why Lydia Tripp
But
testified.
there's no evidence that she said something like, look, I can't do that, please talk to Ms. Carter for me, or anything of that nature.
Right, there's no specific testimony either from Yvonne Jones or Olivia Tripp of anything affirmatively stated by Yvonne Jones. But the circumstances directed everything to Jacqueline Carter based upon her admissions that she was the caregiver. And then also, Jacqueline Carter testified that she had done this before. In fact, at Manora Park, she signed the admission papers. She also signed papers at other hospitals on behalf of her sister. So she held herself out as the representative, signed the agreement as the representative. And also, one of the factors here, consistent with the Brown case in the 2nd District, is that Brentwood had a good faith reason to believe that Jacqueline Carter was the representative. Nothing pointed in any other direction but the fact that Jacqueline Carter was the representative.
Now that good faith belief resulted from the acts of Ms. Carter, not Ms. Jones, is that fair?
It was a combination of the fact that Jacqueline Carter was not capable from a medical
Ms. Jones
condition.
is not capable.
Yeah, from Yvonne Jones. A combination of the fact that Yvonne Jones was not capable or in a condition to engage about the agreement, and also the fact that she was brought there by her representative, Jacqueline Carter, who signed the documents as a representative and admitted in her deposition that she was a representative.
All that seems to imply passive activity by Ms. Jones. She's not done anything after to say, this person's my agent.
And it goes to...
What gives your client the authority to believe that they can take the word of someone else and bind them to a contract when that person isn't speaking, making any representation whatsoever?
Well, this is a situation that nursing homes face, that they have a patient that is not capable of signing papers or reading the documents and is brought in by someone who has explicitly stated that they are the representative, the caregiver, and that they can rely upon that person to make those decisions based upon the history. And also, there, within the contract, from the substantive standpoint that it was conscionable, is that both parties relinquished rights. They agreed to share costs and fees, but also there was the 30-day period in which to revoke the arbitration agreement that was never executed. So it was still in place. So you have to look at the totality of the circumstances of Yvonne Jones on the one hand not being capable or competent to speak to have her agreed, and mostly be able to sign that document in conjunction with representations from Jacqueline Carter on the fact that she is the caregiver, the representative, handles all the money, finances, decisions from a medical standpoint. So,
Counsel, I guess what I'm trying to figure out in my own mind, I understand your apparent authority argument, but is that reasonable for Brentwood to rely upon in the respect that anyone could come in and say that, and if the person that is being admitted to the nursing home is not able to disagree with it because of cognition or whatever it may be, that opens the door to all type of fraud too, doesn't it?
well, I think you have to take it case by case and not a general look at how someone coming in to commit fraud. I think it's within the expertise of the people of Brentwood to assess the situation. I think it's also crucial to know that this was respite care, where the caregiver was bringing the patient, Yvonne Jones, in for a break from her own caregiving. The fact that this was respite care is consistent with the fact that this Yvonne Jones was being cared for at home by Jacqueline Carter, and it's her sister. So there is a good, I think you have to look at the good faith belief and a reasonable belief that Jacqueline Carter was indeed not only the caregiver of everything for Yvonne Jones, but also a representative, and had done so before in signing papers and handling other matters. So for this...
So the person that actually handled the admission process, she did not specifically ask though for a power of attorney or any type of durable power of attorney, anything like that in regard to medical care decisions.
I think it's undisputed that there was not at that time that was in existence, but it's
But did she
reasonable.
ask for it, is what I'm saying? Do you know, do you remember?
I don't think there's any specific testimony because I don't think there's a specific memory. But I think without that, you can still have a representative because people are caregivers and representatives without that. And under this situation, it falls under the apparent authority. With regard to the second assignment of error, because it is kind of interrelated to our first assignment of error on the motion for stay, is that we filed a motion for relief from judgment in order for the court to consider the testimony of Jacqueline Carter. We argued under 60B2 and 5 that this case should be decided on the merits. The testimony of Jacqueline Carter, which we argued was newly discovered evidence based upon when the deposition was taken, the court's ruling, when we got the transcript. And we asked that this court at least remand this matter and have the trial court conduct a hearing and make a ruling based upon Jacqueline Carter's testimony, because that was not considered by the trial court and very crucial to the determination of this case. And for that reason, we ask that both the motion, the denials of both motions be reversed, and this case be remanded for further proceedings. And I'll take up my rebuttal then.
Sure.
Thank you.
Hey, long time no see. So, Your Honors, this case is extremely frustrating to me because it appears that the only purpose here is delay. There is no contract here, and it really kind of highlights the problem with the arbitration statute that lets people appeal no matter what. There's no contract here. Yvonne Jones didn't sign it. That's not in dispute. Jacqueline Carter had no authority to sign on her behalf. That's not in dispute. Olivia Tripp, who's the admissions coordinator, testified, and she was specifically asked the questions that Judge Carr asked. She did not ask Ms. Jones if she could have her sister, Ms. Carter, sign the admission agreement on her behalf. She did not verify that Ms. Carter had legal access to her income, assets, or resources. Olivia Tripp testified that she did nothing to verify that Ms. Carter had any capacity to act on behalf of Ms. Jones. Ms. Tripp testified that she did not ask Ms. Carter for proof that she was in fact authorized to act. She did not request a valid power of attorney. Ms. Tripp testified that she asked Ms. Carter to sign the admission agreement because Ms. Carter was the one who called the facility about bringing Yvonne Jones in. When asked why Ms. Tripp preferred to use a representative to sign the admission agreement and not the resident, she testified that this is just how she did it. Not because that's what she was trained to do, but just because that's how she did it. There's no legal significance to representative or caregiver. You can care for someone your whole life, but if you're not authorized to act on their behalf, you can't act on their behalf. One of the
Is that a term of art in that we say representative? Is that a term of art in their nursing home agreement that they're called a representative?
No, Your Honor.
We're just using that term generically, it's not in the contract or anything else, we say representative.
The only context that I can think of where that term has legal significance is in probate, where a personal representative has been appointed to act by the court. And if that were the case, if there were a guardianship, she'd have the legal authority to act. You know, one of the things that I'm a
When
little...
she signs this contract, she just sign her name, does she sign, a line that says representative? What does the contract indicate?
So in the first part of the agreement, it says, this agreement is made and entered into this day on September 24th, 2018, by and between Brentwood Health Campus, which is not any of the defendants, Yvonne Jones, resident, and Jacqueline Carter, representative. Hereinafter, when capitalized, the term "you" shall refer jointly and severally to the resident and the representative. And then on the signature block at the end of the admission agreement, it provides that Yvonne Jones did not sign, and it provides that Jacqueline Carter just signed as the representative. There's no legal significance to representative.
There's no definition of representative in the contract?
Not that I'm aware of. It's certainly not in the signature block, it's certainly not in the beginning. You know, the Brant case, the daughter had power of attorney. The Brant case is not an apparent authority case. And the other thing that frustrates me a little bit is, and I double checked to make sure I didn't miss it, I don't believe defendants argued apparent authority in their motion to stay. Because as I was reading these briefs and getting ready for today, I was looking for a discussion of apparent authority. I don't see it. Judge Stevenson, you're correct. An agent can't create apparent authority. I can't go down to the Cadillac dealership and say, hey, I'm here to buy a Cadillac and Judge Stevenson promised he'd co-sign for me. I can't create apparent authority. Only the principal can create apparent authority. And by counsel's own discussion, the principal in this case was incapable of creating apparent authority. Yvonne Jones never said her sister was authorized to sign on her behalf. More importantly, the notion that we gotta go back and have another hearing, delay this case further, counsel hasn't mentioned anything in Jacqueline Carter's deposition that would in any way be relevant to the issue before this court. She didn't say anything that contradicted her affidavit. She wasn't authorized, she didn't have power of attorney, she never said she had power of attorney. So in this case, the principal didn't do anything for a power of attorney, the agent didn't do anything to create power of attorney. The facility just had her sister sign.
Can you,
Yep.
and it's quite possibly, nothing in the record is going to illuminate this, but in the trial court's order, it says this matter is not favorable to the process of arbitration at this point in the litigation. That part about at this point in the litigation, is there anything to illuminate why that phrase is in there? And it is possible there is not. I'm just asking a question.
Not that I know of, Your Honor. In the paragraph above, it says the court cannot determine the circumstances surrounding the arbitration agreement make this matter amenable to arbitration, and there's no time on the first one. So the second time, I don't know I don't know why. You know, the court had a second bite at the apple on motion for relief and came back and said it again, so,
Well, amenable to arbitration is also a little outside of what we would normally see in terms of whether someone is bound by contract to arbitrate or not.
true. You know, as you know, Your Honor, you're reviewing this de novo, and so the facts are, Yvonne Jones didn't sign the agreement. She's a living person who's around today who never signed this agreement, and not one of the defendants is a party to this agreement. Under contract principles, you gotta be named in a contract, and you gotta sign a contract. Olivia Tripp didn't know who the defendants were. She certainly doesn't have any authority to sign on behalf of any of them. Brent Clausen didn't sign the agreement.
I'd like to follow up on Judge Hensel's question, because one of the things that I noticed in reviewing, and I understand we review de novo, but we're not, but we are a court of review, and so we don't make decisions for the first time necessarily. What I guess I wanted some clarification on is the court in the final paragraph said the court finds that the arbitration agreement is unenforceable because it is substantively and procedurally unconscionable as applied to claimant. And then it follows up as at this point in the litigation, but the point is the court made the determination based on unconscionability, not on the basis that someone didn't have authority to enter into the contract.
Sure, and the court doesn't address capacity, and I don't know that there's any lawyer in Ohio who's handled more of these enforced arbitration in nursing home than I have. We see this a lot. I think trial courts often grab onto one concept or another and make their decision. They don't feel compelled to kind of address all the arguments, and I've honestly seen trial courts grab onto an argument that I didn't think was my strongest argument. You know, in terms of substantive unconscionability, if we want to argue that none of the defendants are parties and the plaintiff didn't sign, I think that would be relevant to substantive unconscionability. In terms of procedural unconscionability, if we want to talk about the fact that Jackie Carter never said she had authority to sign, Yvonne Jones never said Jackie Carter had authority to sign, nobody explained the contract to Yvonne Jones, nobody explained the contract to Jackie Carter. I mean, I think there is unconscionability, and we argued it in our appellate brief. You know, in a concept like this where the essentially there is no contract. You know, that's my frustration with getting an automatic appeal in these cases. I mean, a nursing home could staple a napkin to a motion to stay, and they'd still get an appeal. I mean, there's no contract. Yvonne Jones didn't sign anything, nobody signed on her behalf. That's game over. None of the defendants are parties, and they didn't sign and they're not named. That's game over.
So are you saying then, when the court says it's substantively and procedurally unconscionable, procedural unconscionability would go to the fact that the appellee here, Yvonne Jones, was not a party to the contract, and there was no contract, so it's procedurally unconscionable to try to hold that against her in these circumstances?
Well, the defense counsel started his argument by saying she wasn't capable of contracting. So So they're here enforcing a contract against a living person who's not capable of contracting, and nobody contracted on her behalf who was authorized to do that.
Isn't that really the same argument as the authority of the sister? I mean, it's the exact same argument, right?
I mean, I think they're all inexplicably linked. I don't think we can really parse them out into separate, factors. I mean, you've got a nursing home resident, and, there's a statute that requires how things are supposed to be. It's supposed to be a separate agreement. It's supposed to be negotiated fairly. It's supposed to be, it's supposed to have certain terms in it. It fails on that basis. She doesn't sign it, and nobody signs on her behalf. And their own admission agreement talks about the requirements to make sure that there's authority. So what they should have done is, if she's admitted and they want her to sign, they get her evaluated. If they determine she's mentally incompetent, they get, power of attorney. I think Jackie Carter testified that she got power of attorney for a subsequent admission. And, because they required her to do that. That's what should have happened in this case. Had they, insisted that Jackie Carter get power of attorney, I don't know that power of attorney is valid at that point if she's not mentally competent to designate it, but maybe she gets a guardianship. But there's a procedure by which somebody's authorized to act on your behalf. Didn't happen in this case. And even if it had, it wouldn't have mattered because none of the defendants are parties. And even if they were, it wouldn't have mattered because it violates the very statute that the legislature passed to keep these things fair. I mean, this is just not a binding arbitration agreement 6 ways to Sunday. I mean, not only did Yvonne Jones not do anything to create a parent authority, Jacqueline Carter didn't either. And the representatives don't even claim they did. That's the thing, when we deposed Olivia Tripp, she doesn't come forward and say, well, I was misled, or I thought, or she says, I just asked her because she's the one who called. That's it. So, I mean, I don't know that there's anything else that's really in dispute in this case. If the panel has any further questions.
I do. So, are you disputing that Ms. Carter acted as if she had authority?
100%. Yeah. What she did was what a lot of people do. You bring your mom into a nursing home, there's a whole bunch of documents, and you sign them. Does she get her nails done? Does she get her hair done? What do we do for this, for Medicaid, for Medicare? And you sign what the person tells you to sign.
But isn't within the agreement itself some verbiage about she is saying she is the representative of
Nope.
Yvonne Jones?
I mean, it says representative at the top there, but it doesn't say power of attorney, it doesn't say I'm authorized to act, it doesn't say hereby affirm.
That's a different question, right?
Right, I mean, look, is she a rep in a very kind of generic sense? Sure, she's the sister bringing her in to check her in the same way that, listen, I went to the hospital the other day and I had to get a ride home and my buddy picked me up, and so if he signed me out, he could have signed as my representative because I wasn't allowed to drive myself after the procedure. Doesn't give him power of attorney, doesn't let him contract for me, right? So she is her caregiver. I mean, legally that doesn't mean anything when we're talking about a contract. And Jackie Carter signed an affidavit, which you have clearly indicated, I don't have authority, I didn't have authority at the time, I didn't tell anybody I did, I wasn't asked by anybody if I did, so this isn't even a case where the agent made misrepresentations. You have those cases, and they still should, the contract should still not be enforced if the agent made a misrepresentation, because that's not how a parent authority works. As a threshold issue, it's an interesting question of whether the court will consider an argument of parent authority when it wasn't made to the trial court or in the appellate briefs. But if we want to consider it, it still fails.
So nothing further. Thank you.
Thank you, Your Honor.
At the outset, I do have to address this issue of what Plaintiff's counsel said at the beginning of the argument, that this was some kind of delay tactic. They raised that. They raised that in a motion to strike based upon delay, and in the second paragraph of the trial court's order specifically rejected that argument. And more importantly, they have not challenged the trial court's finding that there was no delay issue here. So it's just not appropriate to raise that as the initial part of their argument. Second of all, with regard to the representative, that term is used. Exhibit A, pages 10 through 11, describes when a representative enters into it and how they're bound. So there is the paragraph that is part of the agreement, pages 10 through 11 of Exhibit A does discuss representative. Now, with regard to Jacqueline Carter and this issue about apparent authority, the motion we didn't raise apparent authority in the beginning because on the face of it, she signed it as the representative. It was when she then issued an affidavit that we had to explore that issue of her status as a representative. And what's important about the affidavit that was attached to the brief in opposition, she never denies that she was the representative. That affidavit says, I didn't have power of attorney, I was not the guardian, and made a conclusion, I was not the legal representative. Okay, never did she deny that she was the caregiver and that she was the representative of Yvonne Jones on the date of admission. And I point you to page 10 of our brief where we quoted Jacqueline Carter's testimony. And it says, and you didn't leave it to your mother to enter this agreement on behalf of Yvonne, correct? That's correct. Because you were the best person to represent Yvonne's interest in September of 2018, correct? Yes. That day, yes, I was her representative. And that hasn't changed up to today, correct? That's correct. Jacqueline Carter admitted that in September of 2018, she was her sister's representative, authorized to read and sign the contract, admitted that she went through the agreement, presumably Olivia Tripp, she didn't remember the name, but admitted she went through it and signed it as the representative. And just like the Second District Court of Appeals in Brown versus Extended Care, this falls under the apparent authority when there's not a power of attorney or guardianship, that this is where she represented that she was the representative for her sister. And that was appropriate for Brentwood to rely upon and execute this agreement and the arbitration as we did in the trial court. And for these reasons, we ask that this court reverse both judgments of the trial court and remand it and send this to arbitration. Thank you.
Thank you. Thank you both for your presentations this morning, this afternoon. The court will take the matter under advisement. We will issue a decision which will be known to all parties to this appeal as well as posted on the Ohio Supreme Court website.